raise the flag of the United States of America, recognizing the principles for which it stands. Department 107 of the Los Angeles Superior Court, State of California, is now in session. The Honorable Michael E. Pastor, Judge presiding. Please be seated.
In the case of People versus Conrad Murray, Dr. Murray's present with counsel, Mr. Chernoff, Mr. Flanagan, Mr. Gorgian, and Mr. Pena. The people are represented by counsel, Mr. Walgren and Ms. Brazil. All the jurors and all the alternates are present. Good morning, ladies and gentlemen. Hopefully you had a productive day off yesterday. And once again, thank you for accommodating us. In the time when you were off, counsel and I discussed exhibits and jury instructions. Let me advise you that the following exhibits have been received in evidence. And you don't have to feverishly try to write down everything because you're going to get an exhibit list. With the number of exhibits in this case, we can't expect you to memorize each exhibit. So you're going to get an exhibit list, and that exhibit list is going to indicate every exhibit that has been received in evidence. You are going to receive a substantial number of exhibits in the jury room when you begin your deliberations. Other exhibits will not be presented to you at that point in the jury room, but will be available on request if you'd like to see and examine them. Some of the exhibits, which may contain forensic matter, for instance, or medication, for instance, are not, as a matter of court policy, brought into the jury room unattended. I'm sure you can understand that. But they're available, and if you want to view them, you just send us a little note, and we'll have one of our bailiffs bring in that particular exhibit or exhibits. The important thing is you'll have access to any and all exhibits that are received in evidence. And the exhibits received in evidence are Peoples 1 through 53, 56 through 226, 228 through 229, and 239 through 244. The defense exhibits received in evidence are A through J, and then L through SS, VV through XX, ZZ through triple X, quadruple C through quadruple E. Some of you were smiling. A quadruple G through quadruple N, and then quadruple P through quadruple W. Once again, you're going to have a list, and it'll be pretty clear what you're receiving as exhibits and what you are not. If you have any questions, you know where to find me. At this time, ladies and gentlemen, I'm going to be providing you with the legal instructions that apply to this case. Each of you should have a copy of the jury instructions. Do all of you have that copy? It was provided to each of you, and all jurors are indicating the affirmative. As I'm going to be telling you in just a few moments, the law requires that I read the instructions to you in the open courtroom. We feel that it's appropriate to have each juror read along with me. So you have your own personal copy. You receive the master set of instructions in the jury room during your deliberations. You also have your own personal set, which you review at this time and during your deliberations, and it's your personal set. It's yours to keep, and you can write on your personal set. You can make notes or comments on it if you'd like, both now and during deliberations. My suggestion is at some time you may want to put your seat number on your personal copy, so that way if it gets put down, you'll know where to find it. The important thing is you can feel free to write anything you'd like on your own personal copy since it belongs to you. Let me indicate that while I have gone over these instructions on many occasions, there still may be some typographical or grammatical errors. May I suggest that you have a pen handy so that if, as I'm reading it, it becomes apparent that there is such an error, you'll be able to correct it. It should take about 28 minutes and 14 seconds for me to read these instructions to you. That's going to vary by a little bit, but it'll take just about a half an hour for me to read the instructions to you. After I do that, we'll take a break. I think you'll probably need it. And we'll take a little bit of a break, and then the attorneys will begin their arguments, and I'll give you a little more information about it. So if you would turn to page 1, which is always the best page. Page 1 of the instructions. Post-trial introductory series. Members of the jury, I now will instruct you on the law that applies to this case. The law requires that I read the instructions to you in the open courtroom. I will provide you with the written master set of instructions to review in the jury room, during deliberations. In addition, I have provided each of you with a written personal set of instructions to follow at this time and review in the jury room during deliberations. While you cannot write on the master set, you certainly may write on any personal copy. The instructions that you receive may be printed, typed, or written by hand. Certain sections may have been crossed out or added. Disregard any deleted sections and do not try to guess what they might have been. Only consider the final version of the instructions in your deliberations. You must decide the facts in this case. It is up to all of you, and you alone, to decide what happened, based only on the evidence that has been presented to you in this trial. Do not let bias, prejudice, sentiment, sympathy, public opinion, or public feeling influence your decision. Bias includes, but is not limited to, bias for or against the witnesses, attorneys, the defendant, or the alleged victim, based on disability, gender, nationality, national origin, race or ethnicity, religion, gender identity, sexual orientation, age, or socioeconomic status. You must follow the law as I explain it to you, even if you disagree with it. If you believe that an attorney's comments on the law conflict with my instructions, you must follow my instructions. Pay careful attention to all of these instructions and consider them together. If I repeat any instruction or idea, do not conclude that it is more important than any other instruction or idea just because I repeated it. Some words or phrases used during this trial have legal meanings that are different from their meanings in everyday use. These words and phrases will be defined specifically in these instructions. Please be sure to listen carefully and follow the definitions that I give you. Words and phrases not defined specifically in these instructions are to be applied using their ordinary, everyday meanings. Some of these instructions may not apply, depending on your findings about the facts of the case. Do not assume just because I give a particular instruction that I am suggesting anything about the facts. After you have decided the facts, follow the instructions that do apply to the facts as you find them. Do not conduct any research regarding this case on your own, through another person, or as a group. Do not investigate the facts or the law involved in this case. Do not use a dictionary, a Bible, the internet, or any other reference materials whatsoever with regard to this case. Do not access any internet site, including but not limited to any search engine site, such as Google, Ask, Bing, etc., or any social networking site, including but not limited to Facebook, MySpace, etc., or text or tweet, or otherwise post any messages, or access any blogs regarding any aspects of this case or the persons identified in it. Do not listen to, watch, read, hear, or otherwise have any contact with any television or radio program, book, or newspaper or magazine article regarding any of these subjects. Do not perform any experiments or visit the scene of any event involved in this case. If you happen to pass by the scene, do not stop or investigate. If anyone contacts you about this case, wants to discuss the case at the time, or offers you the opportunity to discuss the case at a later time, attempts to offer any opinion on the case, or otherwise tries to influence you in any way, immediately cease such contact and immediately notify the courtroom staff. You have been given notebooks and may have taken notes during the trial. You may use your notes during deliberations. The notes are for your own individual use to help you remember what happened during the trial. Please keep in mind that your notes may be inaccurate or incomplete. If there is a disagreement about the testimony and stipulations at trial, you may ask that the court reporter's record be read to you. It is the record that must guide your deliberations, not your notes. You must accept the court reporter's record as accurate. Please do not remove your notes from the jury room until you are permitted to do so. At the end of the trial, you may retain your notes. If you do not wish to retain your notes, please leave them on the center table in the jury room. The courtroom staff will collect and destroy them. Presumption of innocence and burden of proof. The fact that a criminal charge has been filed against the defendant is not evidence that the charge is true. You must not be biased against the defendant just because he has been arrested, charged with a crime, or brought to trial. A defendant in a criminal case is presumed to be innocent. This presumption requires that the people prove a defendant guilty beyond a reasonable doubt. Whenever I tell you the people must prove something, I mean they must prove it beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt, because everything in life is open to some possible or imaginary doubt. In deciding whether the people have proved their case beyond a reasonable doubt, you must impartially compare and consider all the evidence that was received throughout the entire trial. Unless the evidence proves the defendant guilty beyond a reasonable doubt, he is entitled to an acquittal, and you must find him not guilty. Evidence. You must decide the facts in this case. You must use only the evidence that was presented in this courtroom. Evidence is the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Nothing that the attorneys say is evidence. In their opening statements and closing arguments, the attorneys discuss the case, but their remarks are not evidence. Their questions are not evidence. Only the witnesses' answers are evidence. The attorney's questions are significant only if they help you to understand the witnesses' answers. Do not assume that something is true just because one of the attorneys asked a question that suggested it was true. During the trial, the attorneys may have objected to questions or moved to strike answers given by the witnesses. I ruled on the objections according to the law. If I sustained an objection, you must ignore the question. If the witness was not permitted to answer, do not guess what the answer might have been or why I ruled as I did. If I ordered testimony stricken from the record, you must disregard it and must not consider that testimony for any purpose. You must disregard anything you saw or heard when the court was not in session, even if it was done or said by one of the parties or witnesses. During the trial, I advised you that the people and the defense agreed to certain facts. This means that both parties accept those facts as true. Because there is no dispute about those facts, you also must accept them as true. The court reporter has made a record of everything that was said during the trial. If you decide that it is necessary, you may ask that the court reporter's record be read to you. You must accept the court reporter's record as accurate. Facts may be proved by direct or circumstantial evidence, or by a combination of both. Direct evidence can prove a fact by itself. For example, if a witness testifies he saw it raining outside before he came into the courthouse, that testimony is direct evidence that it was raining. Circumstantial evidence also may be called indirect evidence. Circumstantial evidence does not directly prove the fact to be decided, but is evidence of another fact or group of facts from which you may logically and reasonably conclude the truth of the fact in question. For example, if a witness testifies that he saw someone come inside wearing a raincoat covered with drops of water, that testimony is circumstantial evidence because it may support a conclusion that it was raining outside. Both direct and circumstantial evidence are acceptable types of evidence to prove or disprove the elements of a charge, including intent and mental state, and acts necessary to a conviction, and neither is necessarily more reliable than the other. Neither is entitled to any greater weight than the other. You must decide whether a fact in question has been proved based on all the evidence. Before you may rely on circumstantial evidence to conclude that a fact necessary to find the defendant guilty has been proved, you must be convinced that the people have proved each fact essential to